5 seconds to go. Start. In that background, the evidence of Dr. Gurnamjeet Rai PW2 and of the Sub Inspector Jaswant Singh PW5 would establish that the death had occurred due to organophosphorus poisoning. Hence, as noted, the death was unnatural and there was demand for dowry. In those circumstances, the further evidence of PW1 and PW8, the parents of the deceased would also refer to the circumstances when the deceased had been sent back to the parental home to secure fulfillment of the said demand, but the parents, being unable to fulfill the demand, had counseled and sent her back. It was also stated by them that during such visit she had mentioned about the ill treatment meted out to her. But the question would be as to whether such evidence will be sufficient to hold both appellants guilty of committing the offence. Considering the fact that on all these aspects of the matter, the trial court has referred to the evidence in detail and the High Court has reappreciated the same in its correct perspective to the extent of both the courts holding the appellant number 1 Kuljit Singh guilty, convicting him and imposing the sentence in the manner as done is justified and does not call for interference. The only aspect which requires consideration herein is as to whether the conviction and sentence handed down to the appellant number 2 Raj Rani is justified or not. The learned counsel for the appellant in that regard has strenuously contended that except for making vague statements to the effect that the husband and the in-laws of their daughter had made demand for dowry and inflicted cruel treatment, the trial court had not referred to any specific instances where the appellant number 2, namely the mother in law of the deceased, had been ascribed any specific role in making the demand and inflicted cruelty. As noted from the statement recorded under section 313 of CRPC, the appellant number 2 Raj Rani had denied any role and had also contended that she was not present in the house when death of her daughter-in-law had occurred. It is true that the appellant number 1 Kuljit Singh had also stated that he was not present when the death had occurred. On that aspect, as rightly noted by the trial court, it had come in the evidence through the deposition of Bittu DW1 that he and appellant number 1 Kuljit Singh had taken the deceased to Dr. Kalsi and thereafter to Shri Guru Ramdas Hospital, Amritsar, though the version given by the said witness was because she was pregnant. However, it has been established that such shifting to the hospital was after the deceased had collapsed due to the poisonous substance being consumed. Therefore, though the presence of the appellant number 1 Kuljit Singh was established, the presence of the appellant number 2 Raj Rani was not spoken about. Apart from that, there is no specific evidence with regard to such demand being made by the appellant number 2 or cruelty being inflicted by her pursuant to such demand. From the evidence referred by the trial court, it is noticed that wherever this aspect has been referred to, a sweeping statement has been made that the husband and in laws of the deceased had inflicted cruelty, or it has been stated that the husband and his mother had done so without specifying their roles. However, as already noted, the said evidence would be sufficient to hold the appellant number 1 Kuljit Singh guilty, but same would be insufficient to hold the appellant number 2 Raj Rani guilty. Hence, we are of the opinion that the appellant number 2 Raj Rani is entitled to be acquitted. For the reasons stated above, the conviction and sentence imposed on the appellant number 1 Kuljit Singh is affirmed, while the conviction and sentence imposed on the appellant number 2 Raj Rani is set aside. The judgment dated 8th January 2002 in Sessions Case number 74 of 1999 and the judgment dated 18th January 2011 stand modified to the above extent. The appellant number 1 Kuljit Singh, who is on bail, shall surrender within 2 weeks from the date of this judgment and serve the remaining sentence. The appellant number 2 Raj Rani is set at liberty if not wanted in any other case, and the bail bonds executed by her is ordered to be cancelled. Stop.